Good morning, everybody. Welcome to Shed Gospel. It's Nigel Woolley. Today I'm going to deal with a subject talking about out of control states and the Constitution. So I have some print-offs here that I've got from the Australian Constitution, the 2012 edition that came out off the Federal Register of Legislation. And I'm going to talk about what the role of the states is within the Commonwealth, and having a look at, can states do whatever they want to do, and do we have to obey the laws of states? What's constraining the states, and all of that? Because really what's going on, what I see is going on, that the states seem to be pushing, like challenging one another type thing, outdoing each other competition wise. And we're all residents of a state, aren't we? We're all residents living in different states. But is there any constitutional constraints on states? Okay, I'm going to read some, and bear with me. I've got a lot of notes here to read, but I'm going to read from our Constitution today. And I'm going to also read from this Australian Government Solicitor's Notes from October 2010. So there's a fair bit of stuff here today, so hopefully this video will be a reference video for you. It might go on for a while, but it will hopefully be a reference video for you that you can always go back to later and have another listen if you don't have the time to stay on the video today, but that's okay. Anyway, I'm going to have a read of the preamble of the Constitution, Section 5. It says, "This Act and all laws made by the Parliament of the Commonwealth under the Constitution shall be binding on the courts, judges and people of every state and of every part of the Commonwealth. Notwithstanding anything in the laws of any state and the laws of the Commonwealth shall be in force on all British ships, the Queen's ships of war excepted, whose first port of clearance and whose port of destination are in the Commonwealth." So the Constitution Act itself and the laws made by the Parliament of the Commonwealth are binding on the laws of states. Okay, so that means that the states have to obey what the laws of the Commonwealth say in the cases that they're made. Okay, under Section 6 of definitions, the Commonwealth shall mean the Commonwealth of Australia as established under this Act. The states shall mean such of the colonies. Here's the key word with the Constitution. It starts to call them states in the Constitution, but at that time they were only ever colonies until the Federation. The states shall mean such of the colonies of New South Wales, New Zealand, Queensland, Tasmania, Victoria, Western Australia and South Australia, including the Northern Territory of South Australia, as for the time being are parts of the Commonwealth, and such colonies or territories as may be admitted into or established by the Commonwealth as states. And each of such parts of the Commonwealth shall be called a state. So, the Constitution was the document. It is the act of the British Parliament, but it's the will of the people that created the states. They were only ever colonies before that, Just gets rid of any myths of whether states have been around since day dot, and as such, really, no, they weren't. They were only ever colonies. The Constitution created them as states, even though there was a transfer or an acceptance of the laws of the colonies at that time, So, and the constitutions of each colony, So, but all of that became states. So, the state of Western Australia, the state of New South Wales, the state of Victoria doesn't, as such, the states came into effect in 1901. Okay, so they're just as old as the Federation in that sense. Original states shall mean such states as are part of the Commonwealth at its establishment. So, in terminology, original states are those which were made you know, the ones I've mentioned, you know, the New South Wales, New Zealand, Queensland, Tasmania, Victoria, Western Australia and South Australia, including the Northern Territory of South Australia, are part of the Commonwealth at that stage. Here we go. Part 8, or Section 8 of the Constitution, of the preamble of the Constitution says, application of Colonial Boundaries Act. After the passing of this Act, the Colonial Boundaries Act, which was what divided the colonies up, shall not apply to any colony which becomes a state of the Commonwealth, but the Commonwealth shall be taken to be a self-governing colony for the purposes of that Act. Right. So, I'm going to read, I've got several pages here, okay? So, like I said before, if you've just jumped on the video, by all means, just share the video or save the video off somehow if you want. You can come back to it later. But I'm going to go through some stuff here because really, when states are going out of control and doesn't seem like the federal parliament stepping in to control them, there are some provisions there that allow states to do certain things. But I think here's the thing we have to understand, because most of the time, 9 times out of 10, it's going to be us, the people of the Commonwealth, that have to do the standing up, you know, because if it's something that the states are doing, like at the moment, if the states are doing somehow the will of international people that want Australia to look totally different to what it ever used to be, you know, if the states are the ones doing the dirty work and the federal parliament's not stepping in, not holding them back, not restraining them, just kind of turning a blind eye to what they're doing, then there are provisions in the Constitution that enable the federal parliament to do something. But we have to raise the alarm, you know, that's the thing. We have to raise the alarm, because if they're all in it together, trying to do stuff all together, then we have to know our law. We have to understand what's the principles of what's happening. You know, I'm fairly new to this myself, but I have an affinity for it because it's very similar to the Bible to me. You know, there are founding laws, there are founding principles, there's a founding viewpoint on how to view everything. Okay, so Section 100 of the Constitution says that the Commonwealth shall not by any law or regulation of trade or commerce abridge the right of a state or of the residents therein to the reasonable use of the waters of rivers for conservation or irrigation. So that means that the Commonwealth, but the federal parliament can't abridge the rights of states and the residents of the states to the waters. What's happening down in the Murray-Darling, you know, all that down there. There's a lot of constitutional protections that ensure that under Section 100 that the Commonwealth can't prevent people from having reasonable access to the waters of the rivers. Okay, so specifically dealing with the states now, at Federation, what happened there, Section 106 of the Constitution now, talking about how the Constitution created the states, but what it allowed them to do. I'm going to read here a few sections. So 106 through to 109 of the Constitution primarily is the thing in the Constitution that creates the states, but it gives them the parameters as well and the relationship to the Constitution. Section 106, Saving of Constitutions. The Constitution of each state of the Commonwealth shall, subject to this Constitution, continue as at the establishment of the Commonwealth, or as at the admission or establishment of the state, as the case may be, until altered in accordance with the Constitution of the state. So, it's allowing the state constitutions, which were once colony constitutions, it's allowing them to continue. Wayne Glue put it very clearly this way, which I'll give him the recognition that he deserves, but he says that if it wasn't for these sections of the Constitution that allow the states and their laws and their parliaments to continue, the power of the Federation under the Constitution, the power of the Federation and the powers of the federal parliament effectively would have knocked out the states altogether. There would be no basis for them in the law of the Constitution. But, you know, the provisions in the Constitution has created the states, but has also given them parameters. Okay, if you're going to continue as states, you're going to become a state, but it's going to allow the Constitution, the state parliaments to continue and the state laws to continue. But it's all subject to the Constitution. That's the key word there, subject to, as in subordinate to. Okay? Section 107. You need to remember this. It's very easy to remember. 106, 107, 108, 109. It's easy to remember that. That's the four clauses in the Constitution that particularly deal with states becoming states, and also the restraining powers that the Constitution then puts on the states through the Constitution. It doesn't create the states and then allows them to do whatever they want, you know. States have to follow the parameters of the Constitution. And also the states have to follow, through the Constitution, the states also have to obey the laws of the federal, where they've been given such laws, you know. So that's the founding relationship. You know, without getting bamboozled with all this, it's a very clear relationship. You know, the Constitution is the will of the people, isn't it? The will of all the people of Australia. The Constitution is our will, enumerated in a document, right? The Constitution's our will, enumerated in a document, enacted by the British Parliament, turned into a law that then has created the Australia that we now know. Okay? But in the relationship of that, and because the people of the Commonwealth are the only ones that can amend the Constitution, but the Constitution has created Australia as we know of it, then the people are supreme, aren't they? We're the only ones that can change the Constitution. The Constitution's what's created Australia as such now. And if we're the only ones that can change the Constitution as such, then through referendum, then ultimately the power is with the people. It's a constitutional principle. The power is always with the people. So, this is the way it is. Are you one of the people of the Commonwealth? Yes. If you're one of the people of the Commonwealth, are you viewed as supreme? Yes, you are. Is the sovereignty of Australia lying with you? Yes, it is. Okay? These guys are public servants. You have to understand that very clearly. They're public servants. But because we're being a bit in the dark about the relationship that we have with them and that they have with us, because we're a bit in the dark about that and unaware of the restraints that they have, we're not able to hold them to account. Because we could hold them to account, but if we don't know how to hold them to account, then, you know, the problem is that we're not restraining the powers of what we've created type thing, you know? So this is it. Saving powers, section 107. So again, 106, 107, 108, 109 of the Constitution. 107 says, saving of power of state parliaments. Every power of the parliament of a colony which has become or becomes a state shall, unless it is by this Constitution exclusively vested in the Parliament of the Commonwealth or withdrawn from the Parliament of the state, continue as at the establishment of the Commonwealth or as at the admission or establishment of the state, as the case may be. So the Constitution has allowed the New South Wales State Parliament to continue, which at one time was the New South Wales Colonial Parliament. It has now created them as a state parliament, but it allows them to continue and allows their powers to continue. Okay? So section 108 says, saving of state laws. Every law in force in a colony which has or becomes a state and relating to any matter within the powers of the Parliament of the Commonwealth shall, subject to this Constitution, continue in force in the state, and until provision is made in that behalf by the Parliament of the Commonwealth, the Parliament of the state shall have such powers of alteration and of repeal in respect of any such law as the Parliament of the colony had until the colony became a state. So that's allowing these state laws to continue, which at one stage, again, at one stage before the Constitution, before Federation, at one stage the states were colonies. It allows the colonial laws to continue, but now become state laws through Section 108 of the Constitution. Section 109 of the Constitution. Here's the big one here. And you have a look at it in the annotated Constitution by Quick and Garan. It actually says about Section 109. It's got some pretty clear explanations of it. Inconsistency of laws. So this is a big one. When laws of the state are inconsistent with laws of the Commonwealth. When a law of a state is inconsistent with a law of the Commonwealth, the latter shall prevail. So the law of the Commonwealth shall prevail. So that's the laws made by the Federal Parliament. The law of the Commonwealth shall prevail, and the former, the law of the state, shall, to the extent of the inconsistency, be invalid. So what that means is that, say you have some act of a state parliament and some act of a federal parliament. Say, for example, the federal parliament deals with something specific to you, but the state has then made some law that is inconsistent with the law of the federal. The laws of the state, in regard to that matter, where it's inconsistent with the law of the federal, is invalid. It may not mean the whole of that act, of the State Act. It might not mean the whole of that one. It might only be a section of it, or a couple of clauses of it. But it negates the power of that law in the state and says, no, well, you're subject to the law of the federal in this case. But who's going to work that out? Who's actually going to determine that? Is it going to be a judge? Well, it may not be a judge, because a judge might not have a case presented to him that involves that clause. He might not have, what if it's local court? What if it's Supreme Court of a state or something that technically doesn't have the powers in some way to determine that? So I'm just saying, that it may be up to us as individuals to determine, right, as people of the Commonwealth, may be up to us to point out that there is inconsistent with the law of the federal, I'm not obeying it, And that when it goes to a court, the judge will then have to see the matter for sure. But if it's up to us, we're going to have to know if the law of the state is inconsistent with the law of the federal. Okay? So, Section 109 of the Constitution is very clear about that. Who does the ultimate say-so reside with? It is the Federal Parliament on matters where they're inconsistent. States can have big powers to do things under the Constitution. States can still do a lot of things that the Parliament may have not voiced anything on, the Federal Parliament may have not voiced anything on, or the Constitution may not exclusively say. So states can somewhat have a lot of powers to do certain things. But this is where it is that we have to be able to determine something that is, if the state's got a lot of powers to do something, we've got to check out, all right, where are they drawing these powers from? Who gave them, how did this come to be? What's the reasoning behind it? And is it inconsistent with the law of the federal in that case? Especially in something that encroaches on our rights. And I'll get to that a bit later. Because there is some stuff, I think, that's going to protect us. But we need to know. Okay, so Section 117 of the Constitution says rights of residence in states. So you have rights of being a resident in a state. A subject of the Queen, resident in any state, shall not be subject in any other state to any disability or discrimination which would not be equally applicable to him if he were a subject of the Queen resident in such other state. So what that means, Section 117 of the Constitution means that if you're in Queensland, for example, and you're being persecuted for something in Queensland by the Queensland state government, but wouldn't apply to you if you lived in Victoria, that means that Section 117 of the Constitution prevents states from discriminating against you unequally, as if, that's not equally applicable anywhere else in Australia. Okay? So you have rights as subject of the Queen to not be discriminated against by an out-of-control state parliament or state government making laws that suit themselves that discriminate against you. Say, for example, what happens down in Victoria with the Conversion Practices Bill, that's pretty clearly trying to encroach on a free exercise of religion, or when somebody comes to someone else of their own consent, their own free will, they come along and they ask for some help that could potentially fall into the category of a conversion therapy or something like that, then the bill that Daniel Andrews is proposing for Victorians is that it somehow discriminates against religion or practices that they consider, that the state government's considering that those practices are going to not be allowed in Victoria, for example. Right, so that's Victoria acting out, trying to create some set of laws. Okay, there's a lot wrong with Victoria for sure. 100%. Victoria's not standing lawfully, really, as far as I can tell. But anyway, they're trying to do that stuff. But does that apply to you if you lived in New South Wales? No. See, that is against Section 117 of the Constitution, which means that just because you live in Victoria, that means that, you're then subject to that thing. But if you lived in another state somewhere else, you wouldn't be subject to that thing. And if that thing is discriminating against you or a disability against you, say, for example, you can't speak out on a certain subject, or you can't read from a certain passage of the Bible or something in Victoria, but you're allowed to do it in Western Australia or Tassie or somewhere else, then Section 117 of the Constitution is making sure that you have rights, that you have equal rights anywhere in Australia to be the same, okay? Actually, the parliaments have the issue, they have the responsibility to make sure that your rights are preserved, that you are equally valued everywhere in the Commonwealth the same, okay? That's it. Section 118 of the Constitution says, recognition of laws of states. Full faith and credit shall be given throughout the Commonwealth to the laws, the public acts and records, and the judicial proceedings of every state. So, that there is allowing that state laws do have powers, certainly within the state to do certain things. But that's it. They're given parameters to operate within. If they can't give full credit to the laws of a state that's inconsistent with the Constitution, or it's acting outside of their boundaries. Full faith and credit shall be given throughout the Commonwealth to the laws, the public acts and records, and the judicial proceedings of every state. But that's it too. The laws, that's the key word there. The laws, I would say there that reading into it, you've got potential to have unlawful laws, don't you? Or laws that are acting outside of the powers granted or something. If a law of the state is inconsistent with the law of the federal, that doesn't mean that the Commonwealth has to recognise that law of the state. See? So it's just saying in a generic way that states have jurisdiction granted in certain things, and that the laws of the Commonwealth, throughout the Commonwealth, that the Commonwealth shall basically have respect for those laws. So that's okay. Okay, Section 119 of the Constitution. This is interesting, this one. Protection of states from invasion and violence. The Commonwealth shall protect every state against invasion, and on the application of the executive government of the state against domestic violence. So the Commonwealth has powers to step into matters within the states where the states are basically calling on the Commonwealth to deal with the matter that's within the state. The Commonwealth shall protect every state against invasion. What about when Daniel Andrews, for example, what if Daniel Andrews has signed up Victoria or Melbourne to the Strong Cities Network? You know, that was something we all noticed last year when Daniel Andrews had signed up Melbourne to Strong Cities Network. I don't know the machinations or what goes on with Strong Cities, but I have seen those officers that were part of the riot squad down there in Victoria. You know, if they were being flown in from overseas or wherever their training was coming from, if Daniel Andrews is creating a private army down there in Victoria through the police and through Strong Cities Network that he's signing up with, I don't think he's got the power to sign to Melbourne up to any Strong Cities Network, which is an international allegiance. I don't think he has the powers. But the Commonwealth has a responsibility to make sure that the residents in Victoria are protected against invasion, even if Daniel Andrews is signing up Melbourne to the Strong Cities Networks. You know, so that's I think that is a red flag to me, that one. That the Strong Cities Network thing. It's a dangerous thing. So, but anyway, hopefully that gives you some basic understanding from the Constitution of how states have been set up, what they're situated, how the Commonwealth is to protect them, and also to... there's another section of the Constitution that says that states may not raise forces. Do you know that one? I didn't write that one down, but states may not raise forces. So I would say that Daniel Andrews creating private armies with Strong Cities Network, getting extra cops in from overseas or whatever he's doing down there. I don't even know what he's doing, but if that's what he is doing, potentially he is raising forces. So that the intention of states may not raise forces actually comes from, I think it might be the Bill of Rights, 1688, round about then maybe, or the Bill of Rights, the Old English Bill of Rights, which is still in our law foundations here in Australia. It could be that one. I don't quite remember. I think it is Bill of Rights, but it does say in one of those ones, like Bill of Rights, about how basically that you're not allowed to create your own private army. And that's where I think that's where that's been derived from, because when you look at England's history, how they were trying to use the ecclesiastical courts to, with Rome trying to take England back over, they were trying to use ecclesiastical courts to create another king that then could have his own private army that could then take over England. You know, so that's the flavour of that one there. That's where that's come from. Could the same thing be happening in Australia? If you have a private army being raised from within, even through paramilitary or a police force in some way, or some riot squad, you know, that they can create a private army. You know, there's that section of the Constitution that says that states may not raise forces. So, you know, we have rights, guys. We do have rights. And they do say often that our Constitution doesn't have any rights in it. Well, it sort of does, but it in fact sets out the framework in which we can find our rights. You know, our rights may not be written in all the ways that we want to see them, like a Bill of Rights in the Constitution, but you can derive it from the way that Section 109 works of the Constitution, that makes laws of the federal have state effect. You know, for example, we have a Human Rights Commission Act. We have a Human Rights... In the Human Rights Commission Act, there's the Universal Declaration of Human Rights talks about our rights in there. That is then a law of the federal. Okay, it's an international treaty, but they've also incorporated that within the Act itself, right? So that then would have effect through Section 109 of the Constitution that works in the states, you know? Okay, now here, what I have, I've essentially highlighted some sections out of it's called the Australian Constitution 2012, which is just the Constitution, but they've put a thing in the front of it, which is some an introduction by the Australian government solicitor, whoever that is. I don't even know who that is. But anyway, it's got some good stuff in there, and it reinforces what I'm telling you. I'm going to read some of it, okay? It says here, the Australian Constitution has properly been described as the birth certificate of a nation. It also provides the basic rules for the government of Australia. Indeed, the Constitution is the fundamental law of Australia, binding everybody, including the Commonwealth Parliament and the Parliament of each state. Accordingly, even an act passed by Parliament is invalid if it is contrary to the Constitution. So that's what it says there. You know, if you've got any doubts, if you've got some state guy saying, well, look, the Constitution doesn't matter anymore. If some copper saying, well, I don't know much about the Constitution. I'll tell you what, this actually says it's binding on everybody. Okay? So it doesn't matter. If he doesn't, that's the thing, if the copper doesn't even know anything about the Constitution, he shouldn't be getting paid because he's supposed to know. He's supposed to be there making sure that we have, you know, peace in the Commonwealth. You know, if he's actually an officer or if he's a policeman that is supposed to be enforcing the law, then, and if he doesn't know anything about the Constitution or how that works, functionally how that works, then he needs to go back to school because, you know, it's as plain as day, you know, or he's trying to defraud you of something, potentially, isn't he? What if he's one of the private army guys that is trying to take over our country, you know, and he's dressed up as a copper? The background of the Constitution. So I'm going to keep reading on this thing. The background of the Constitution. The Constitution was drafted at a series of conventions held during the 1890s and attended by representatives of the colonies. Before the Constitution came into effect, its terms were approved, with one small exception, by the people of New South Wales, Victoria, Queensland, Western Australia, South Australia and Tasmania. Right? So it was approved by the people, by you guys. It was approved by you. So that means that you are supreme. In effect, this is not telling you the truth either, really. It's kind of laying it out in an easy way to understand. But really, the thing that no one wants to actually tell you is that you are supreme. The sovereignty of Australia lies with you. If Australians knew that, they'd be like, well, look, why have we got a government out of control? And that's exactly it. Why do we? But, you know, this was written in 2010. So this is not old news. You know, this is not something from 1901. Even in fact, the Constitution in 1901 still is in effect, isn't it? The Australian Constitution was then passed as part of a British Act of Parliament in 1900 and took effect on 1st of January 1901. A British Act was necessary because before 1901, Australia was a collection of 6 self-governing British colonies, and ultimate power over those colonies rested with the British Parliament. So at that stage, why they needed the British Parliament to do it, to pass the Constitution, was because that there was not the power in Australia in colonies, in the self-governing colonies, there was not the power in them to pass this act, to create a federation. So that's why they had to go back to England to get it done. In reality, however, the Constitution is a document which was conceived by Australians, drafted by Australians, and approved by Australians. Right? If you've got any doubts, if someone says, oh, the Constitution is just an act of the British Parliament. Well, it is, because at that stage, the colonies had no power to pass the thing. Yes, it is an act of the British Parliament, right? But it's enumerating the will of Australians, isn't it? On what Australians want Australia to be. So therefore, if you're an Australian, your will has been expressed in the Constitution to the parliaments of the federal and the Parliament of the Federal and the Parliament of the States, and it's created many things. Since that time, Australia has become an independent nation, still with the Queen though, and the character of the Constitution as the fundamental law of Australia. See, even this is saying that the Constitution is the fundamental law of Australia. Right? You're quoting the Constitution is fully lawful at all times. Even if people hate you saying it. If people are trying to vilify you for speaking of the Constitution, it is the fundamental law of Australia. And this was written by Australian government solicitor. So you have all full rights to remind them of the Constitution. Okay. Since that time, Australia has become an independent nation, and the character of the Constitution as the fundamental law of Australia is now seen as resting predominantly not on its status as an act of the British Parliament, which no longer has any power over Australia, but on the Australian people's decision to approve and be bound by the terms of the Constitution. That's clearly saying there that its power now is not in the fact that it was created by the British Parliament, but it's the will of the Australian people. And that it's the Australian people's decision to be bound by the Constitution and to approve the Constitution that gives it the effect. That's it. The power is with the people, always in Australia, isn't it? If you're one of the people of the Commonwealth, then the power is with you, isn't it? So refreshing. It's so basic, but it's so refreshing. When you look at all that's going on, you realise the media is acting out of control. We've got parliaments acting out of control, somewhat, because we're not holding them to account, but we can, you know. They should be holding each other to account, but a lot of them are kind of not doing that, I think. Here, some more. What has been judicially described as the sovereignty of the Australian people is also recognised by Section 128 of the Constitution, which provides that any change to the Constitution must be approved by the people of Australia. So what he's saying here is that the sovereignty of Australia lies with its people. And because it lies with the proof of that it lies with the people is the fact that the people are the only ones that can actually change the Constitution. That's it. That's who the ultimate say lies with, is us. Not the government. Okay? Not the parliament. Us. Right. I'm going to read a bit more of what his commentary or notes are. Creation of the Commonwealth of Australia. On the commencement of the British Act on 1st of January 1901, the Commonwealth came into being and the 6 colonies became the 6 states of Australia, covering clauses 4 and 6. The Constitution establishes a federal system of government. It is for this reason that the establishment of the Commonwealth in 1901 is often referred to as federation. Under a federal system, powers are distributed between a central government and regional governments. In Australia, that distribution is between the Commonwealth and the 6 states. So it's saying here that the Commonwealth is a central government and the 6 states are regional governments. You know, and the territories type thing, you know. The relationship between the Commonwealth and the territories is discussed below. So, reading on. This will just get rid of any doubts that you might have, hopefully. For one, you're supreme. Your will is expressed in the Constitution. All are bound by the Constitution, even you. But everyone, certainly the government, the High Court, everyone is all bound by the Constitution. You know, the Constitution created the High Court anyway. So that's why the High Court are the only ones able to interpret the Constitution. It's good to know, isn't it? Okay, the states and their legislative powers. So this is a commentary again in the Constitution 2012, which just includes these notes in the front. It's quite good to read. The states and their legislative powers. Under the federal system created by the Australian Constitution, the 6 former colonies became the 6 states of Australia, which is what I said before. Before Federation, each of the 6 colonies had its own constitution, and the constitutions were set in place with the letters patent, weren't they? These constitutions regulated, amongst other things, the legislature, the executive government and the judiciary of the states. The Australian Constitution expressly guarantees the continuing existence of the states and preserves each of their constitutions. Otherwise, what would have happened? At Federation, if they had not made the provision there through section 106 onwards of the Constitution, if they had not made the provision in the Constitution for the states to continue, for the states' constitutions to continue, what would have happened is that the federal the federal government, the federal parliament would have completely knocked out the states. There would be no law basis for the states, put it that way. Probably make it clear for you. There'd be no law basis for any of the states to exist. However, the states are bound by the Australian Constitution of the Commonwealth. And the constitutions of the states must be read subject to the Australian Constitution, sections 106 and 107. So this is clearly saying here that the states just can't make it up and do whatever they want to do. They all have to be subject to the Constitution. All their laws have to be even read within the context of the Constitution. Under the constitutions of each of the states, a state parliament can make laws on any subject of relevance to that particular state. Subject to a few exceptions, the Australian Constitution does not confine the matters about which the states may make laws. The most important exceptions are the states cannot impose duties of customs and excise, section 90, and cannot raise defence forces without the consent of the Commonwealth Parliament, section 114. Accordingly, the state parliaments can pass laws on a wider range of subjects than the Commonwealth Parliament, and for this reason, important areas such as education, criminal law and roads are regulated primarily by laws of the states rather than by laws of the Commonwealth Parliament. But again, in context, the laws of the states are allowed to continue, but subject to the Constitution. What does the Constitution say? That if the laws of the state are inconsistent with laws of the federal, then what prevails? Laws of the Commonwealth, don't they? So, I mean, even within this, there's still always a provision there that laws of the federal can override something in the states if it's inconsistent. Relationship between Commonwealth and state powers. Although the state parliaments can pass laws on a wider range of subjects than the Commonwealth Parliament, the Commonwealth is generally regarded as the more powerful partner in the Federation. One of the principal reasons for this is section 109 of the Constitution, which provides that if a valid Commonwealth law is inconsistent with the law of a state parliament, the Commonwealth law operates and the state's law is invalid to the extent of the inconsistency. So if there's any doubt, if anyone ever says that, oh, well, look, section 109 of the Constitution doesn't matter anymore, they've proved that it doesn't matter. Well, look, then why on earth is the Australian solicitor back in 2010 saying that section 109 of the Constitution is still in effect? It can knock out state laws. Can. Accordingly, the Commonwealth can, within the subject matters conferred on it by the Constitution, override state laws. As a result, many subjects of Commonwealth power are regulated almost entirely by Commonwealth law. For example, bankruptcy, marriage and divorce, and immigration. So, the big one that concerns us is our rights. isn't it? Rights. What's going on with the states and our rights? Can the states have all these powers to overrule our rights? No, they can't. Let's get into it. Rights. The Constitution has no Bill of Rights. Well, it's pretty obvious, such as that found in the United States Constitution, which prevents a legislature from passing laws that infringe basic human rights, such as freedom of speech. Some express protections, however, are given by the Constitution against legislative or executive action by the Commonwealth, but not by the states. This is where I think it's actually a bit dodgy too, because they're trying to, I think, there is an agenda to try and corrode our rights, but doing it through the states. You know? But here's the thing. If you have a federal active parliament, say for example the Human Rights Commission Act that gives you rights, that, well, it doesn't give you rights, it just enumerates the rights you have and puts boundaries on states or other things that are trying to encroach your rights. For example, you have the freedom of expression, the freedom of, conscience, the freedom of, to not be subjected against your will to medical or scientific experimentation. That's now a law of the federal, okay, through Section 109 of the Constitution, but it's in the Human Rights Commission Act. So therefore the states cannot take away that right that's enumerated to you through the Human Rights Commission Act. You know, even if they want to make it 100% everyone in New South Wales gets vaccinated, for example, that's transgressing something in the Human Rights Commission Act. This is understanding the relationship of how this is working. It's not very, I don't think it's very good, but it's something, you know. And understanding the relationship of how these things work can give you the powers. And this is how they're also using it to their advantage in bullying, I think. You know, to say that everyone's going to be subjected to this thing. But then if you have a look at the Human Rights Commission Act, it says that you can't be subjected without your will to medical or scientific experimentation. And you can put a vaccine in that category, especially one that's been rushed, you know. So really, Section 109 of the Constitution will make it unable for New South Wales to make a law that says, well, they might try, they may even pass it, but the section of the law that says that you shall be subjected to medical or scientific experimentation through a vaccine type thing, then you go back to the Human Rights Commission Act and say, look, based on Section 109 of the Constitution, the Human Rights Commission Act says here in one of the articles that I'm not to be subjected to any medical or scientific experimentation. So, that's it. But herein is the great thing that herein is the thing that they're exploiting. Because when you have a look at laws of the Commonwealth, and say for example the Privacy Commissioner, the Federal Privacy Commissioner, he's only able to deal with breaches of the Privacy Act that's done by the Federal Parliament, not by the states. Same thing with Human Rights Commission. They can only deal with breaches of your human rights done by the Federal Parliament, not by the states. Even though they see what's happening in the states, even though you're one of the people of the Commonwealth, their restriction on their powers to act is limited to only that which laws are done by the Federal. And I think that's a danger. That's actually a problem, because when you have states that are going out of control, you might have rights that are enumerated to you from the Federal, but to stand on your rights, you have to stand on your rights, but the Human Rights Commission Act can't necessarily get involved on your behalf to prosecute the breaches that are done by the states because of the limitations of their powers. Isn't this a loophole? It's like a crack that all this evil could actually fall, you know, basically you could fall into this crack here and be stuck because you're not obeying the law of a state because it's invalid, but yet you can't get the Human Rights Commission Act to the Human Rights Commission to act on your behalf to prosecute the state that's doing the breaches. There's a problem there, isn't there? You know, but this is why I'm doing this video, so that you can clearly see that this is how you're going to have to go about it. This is how you're going to actually have to stand up for what's right. And I think really we should actually be campaigning to get the powers amended of the Human Rights Commission, because, you know, if they're overseeing breaches that are done by the federal, but the problems are coming from the states, you know, they've got their hands tied, you know. But you know, this is where we've got to stand up, and we've got to create trouble type thing, create lawful trouble for our states that are going out of control, you know, and based on the protections. We can't afford to have our states bypassing our Human Rights Commission and being unable to be prosecuted for their breaches. We can't afford to have that happen. We can't afford to have ScoMo like one day saying that vaccines are going to be mandatory for everyone, and then backtrack the same day saying, look, as mandatory as possible, which basically under Section 51 of the Constitution says that they cannot civilly conscript you to take medical stuff at the federal level. But now what they're trying to do is then pass this on to the states, that is going to try and make the states do it, where it's, you know, basically persecuting you into taking it, which is against the Human Rights Commission Act, which says that, you know, that you're, you know, the state may not even have the power to force you to do it, but they might start persecuting you for not doing it, you know. And there's actually provisions there, I think, that we have the right to self-expression and the right to many things that you can even sort of put over the top of the vaccine, you know, really, with things like that. But it's up to us now. It's up to us. This is our Commonwealth, isn't it? We're Australians. This is our country. We are supreme. We are sovereign in Australia. The sovereignty lies with us, not with the Parliament. Not with the states, but it's with us. So we have to stand on our digs, and we have to stand up, and we have to actually know, watch out for the pitfalls in this thing. They're there. We've got some good stuff. The protections are there, somewhat, but the pitfalls are also there. So we've got to be able to navigate it and create some fuss until we get this done the way we want it done, and we get all of our rights fully empowered everywhere. So God bless you, friends. See you later. Catch you later. Bye bye.